All right, we're back on the record on State versus Loyd. He's present with his attorneys. State Attorney's Office is present. We're not going to start until 10 o'clock tomorrow morning so we can solve the medication issue with the juror. Okay. Jury instructions. Let's take them one at a time. Everyone can remain seated during this. 3.1 and 3.2, any objections? Okay. I can't hear you. You don't have your mic on. What?
My client is indicating that he would like to waive his presence to this part.
That he what?
He wants to leave.
All right, Mr. Loyd, you have a right to be present during jury charge conference. Are you aware of that?
Yes, ma'am.
All right. I'm happy to have you remain for the entire thing, but are you saying that you do not want to be present during this time?
No, I'll waive.
Okay. And you understand that if we make decisions on these final jury instructions, you are waiving objections you might have that your attorneys might not make?
I don't know nothing about it, so I wouldn't be able to say nothing anyway.
All right, so you want to waive your presence for jury charge
Yes.
conference? All right, thank you, sir.
I'm
Have a
relying
good
on my
evening.
attorney.
We'll see you tomorrow.
All right.
Take care, buddy. Okay, so you said 3.1, Judge?
3.1, 3.2, any objections?
No objections.
Okay. Here, I can move to the center again.
Tried all day.
7.1, introduction to homicide.
No objection.
Justifiable homicide,
No objection.
excusable homicide,
No objection. Judge, do we leave, on the justifiable, is that standard to leave in the dwelling house?
that's part of the standard instruction
Okay,
on the justifiable homicide?
yes,
That is the standard instruction.
okay.
7.2, first-degree murder of a law enforcement officer.
No objection.
Your Honor, if the court is inclined to give the heat of passion instruction, this is where it would appear at the end of this instruction.
Right.
Others. So I don't know if you want to press the heat of passion at this point in time.
Okay, let me just read through this one more time. This looks like the same one we had the first time, and I didn't see anything wrong with it. Okay, so that was going to be one of my questions, which is heat of passion. All right, first of all, State, are you objecting to heat of passion?
Yes, Your Honor. I don't feel that there is any evidence to support a heat of passion instruction. The claim of the defense in this case has been either insanity or self-defense. I don't see any record evidence to support that the killing was done out of an unreasonable fury or blind and unreasoning fury, which is kind of the focus of the heat of passion instruction.
The case law is pretty clear about the scintilla of evidence. I mean, someone could interpret Mr. Lloyd's testimony to be heat of passion. I'm going to read it.
Yes,
Now,
ma'am.
the question now becomes, I read this, I made some notes, I left them all at my house this weekend. So, State, do you have any specific objection? You've objected to the instruction. Do you now have any objections to the requested instruction?
No, Your Honor. I believe it tracks the statutory language, and what I will do is incorporate the defense's language into the jury instructions I provided at the end of the applicable counts.
Okay.
But I didn't see any discrepancies with the proposed instruction and the standard instruction. I'll read over it again tonight, but
All right, so here's what I normally do when it's the same instruction over and over again about the lessers, which is I don't read every single line of this. I just tell the jurors, you have it in writing, and I've been affirmed on this. You have it in writing. It's the same instruction, but it applies to this lesser, as opposed to reading this for every single, because it is the identical instruction for each one.
Okay.
All right.
No objection by the state.
All right, thanks. All right, 6.1, Introduction to Attempted Homicide. Any objection? Still reading?
Yeah. No objection.
Justifiable, I can't talk anymore, attempted homicide. Any objections?
No.
Excusable attempted homicide.
Rich, I'm not seeing those in this.
What?
I'm not seeing the instructions you sent me. What page are we
You
talking
don't see
about?
this instruction? It's on page 7 and 8.
I downloaded it from the.
Oh,
I just emailed Mr. Lenneman the copy of the instructions I sent earlier. Let me find it, Your Honor.
Okay. So, 6.2, attempted first-degree murder of a law enforcement officer. This is the first lesser. So normally what I do when I'm reading that heat of passion is I just insert it after each lesser, like break it up and insert it. You understand what I mean? Instead of reading it as one long heat of passion, because it does become confusing, because I haven't even told them what the lessers are yet. I break it up and put it behind each lesser.
Want a separate heat of passion instruction then?
Yeah,
Yes, ma'am.
so you understand what I'm saying? It doesn't
So.
go, okay. So the heat of passion is being requested only as to the killing of Debra Clayton, correct?
correct.
All right. So it's just as to Debra Clayton, and then the lessers on first-degree murder of a law enforcement officer. You following what I'm saying?
One heat of passion instruction applicable to all, for the count one and all of its lessers? Or do you want
Correct.
the heat of passion language at the end of count one and at the end, again, at the end of each?
Yes, so that so they don't get confused.
Count one and again at the end of each of the lessers.
Yeah, it's 66 pages of instruction, so yes, please. As to count one only.
Yes.
At least when it printed 66 pages, including the verdict forms. All right. So 6.2, this is count two, attempted first-degree murder of a law enforcement officer. This is the count that goes to Captain Carter.
No objection. I see.
Count three, aggravated assault, 8.2.
No objection.
Count four, carjacking, 15.2.
That's a standard, right?
Yes.
It's been a while since I've done a carjacking, but it looks like the standard to
No
me.
objection.
Count 5, possession of firearm by a convicted felon, 10.15.
No objection.
Three point four, lesser included. This is going to be as to first-degree murder of a law enforcement officer. These are all category ones: first-degree murder, second-degree murder of a law enforcement officer, second-degree murder, and manslaughter. If I remember, I pulled it out, and I think these are all the category ones, right? Yes, sir. Are any category twos requested? State. Defense?
I'm just looking, Judge.
Okay. Glasses is the other one.
So it's second-degree murder and what? Because I don't have it in front of me.
Second, what?
What are the lessers?
Hold on. Hold on, because this isn't actually my book, so it's not marked the way mine is.
These are the category ones. No, let's take it out.
All right, 7,
I'm seeing it now, Judge. I have no objection.
Not requesting any category two.
you're not requesting any category twos? All right. So actually, the only, yeah. So first-degree murder, second-degree. All right. So, good. 7.2, first-degree murder. This is without the law enforcement element as to count 1. Any objections?
No objection.
Correct. 7.4, second-degree murder of a law enforcement officer.
No objection. Why don't you take over, Ted, so you've got another point.
And
Ted's
this
taking
one-
over for me right now, Judge.
I'm sorry, what?
Ted's taking over.
You taking over? Okay. Will you be responsible in front of a microphone so I can hear you?
No.
Will you be responsible in front of a microphone so I can hear you? Oh, sure. Yes. All right, so this one has heat of passion at the end of it. All right, Mr. Moreau, any objection to 7.4 with the addition of heat of passion at the end?
No objection.
All right. 7.4, murder in the second degree, removing the element of law enforcement. Any objections?
I'm sorry, 7.7?
7.4, murder in the second degree, no,
Right,
no law
no.
enforcement designation.
No objection.
All right. 7.7, manslaughter.
No objection.
And then this would be the last one that has a heat of passion at the end.
Don't think it applies to manslaughter, but I'll check in the statute if it does.
You know, I don't know the answer to that.
Probably not, Judge.
Defense, Mr. Moreau, you think heat of passion applies to? That's a good question.
I've never thought about it, but probably not
It probably wouldn't, just because of the nature of manslaughter.
precisely.
So, oh, good, that's less times I have to explain it.
Culpable negligence, it doesn't make sense.
That's right, because this wouldn't be a heat of passion, so you're right. 7.7, without a heat of passion. All right. 3.4, lesser attempts on attempted first-degree murder of a law enforcement officer. So these are also category 1s that are listed here. State, are you requesting any category 2s on this one? No, Your Honor. Defense?
Just a second, Judge.
This would be 6.2 is the standard. Well, there is one that's missing, which is attempted aggravated battery. And we're going to talk about them just because they're category ones. I want the record to be clear. The category ones on this one are attempted second-degree murder, attempted manslaughter by act, attempted aggravated battery, intentionally caused great bodily harm. I don't think that one's applicable, but I'll hear the defense if you want me to. Captain Carter wasn't shot. And he wasn't injured. You know where I am?
Judge, I'm pulling up, I didn't have the category twos, so
This is category ones I'm talking about. Attempted ag battery is a category one of attempted murder. As
Right.
is attempted battery. But both of those require some kind of touching, and there wasn't in this case. I just want the record clear on this, that you're not requesting it. And then I'll get to the category twos.
At this time, Judge, we're not requesting it.
All right, any category
category
twos
two.
that are being requested?
Not by the state.
You good on these category ones? Attempted first, attempted second of a law enforcement, attempted second, and attempted manslaughter by act. All right.
That's
Is
on
that a
fine,
yes?
Judge. Yes, Your
Okay.
Honor.
6.2, attempted first-degree murder. This is without the designation of law enforcement for Captain Carter.
Right, no objection.
All right. 6.4, attempted second-degree murder of a law enforcement officer.
No objection to that either.
6.4, attempted second-degree murder without law enforcement designation of Captain Carter.
No objection.
6.6, attempted manslaughter by act.
No objection.
3.4, lesser included of aggravated assault.
No objection.
Any category twos requested by state, defense?
No, Your Honor.
All right, so we're reading improper exhibition of a firearm and assault, the two category ones. 10.5, improper exhibition of a firearm.
No objection.
Assault. Any objection?
No, Your Honor.
All right, 15.2 is carjacking, and so, get to that one.
I believe there's a category one lesser of carjacking act assault, which I did not include because it's separately charged as count 3.
It's actually assault. It's not even ag assault, it's just assault. So, all right, so,
Provides a lesser of a separately
Right.
charged count, so I didn't include it.
yeah, ag assault is the category 2 for some reason. I'm just looking at it. I don't write this stuff, I just read it off. The category ones are robbery, grand theft of a motor vehicle, and assault if assault was charged. And then we have aggravated battery. The category twos are aggravated assault is listed under category 2. I'm just reading it. So let me start with, Mr. Marrero, is the defense requesting assault as the category 1, or are you waiving that one?
I, and, let me see here. I mean, we'll ask for it, Judge. We're
You
not
want
waiving
it?
Yes.
Okay, so we're going to reread assault.
Or the court can just instruct.
8.2, well, I need it in the written form.
Okay.
I'll just tell them it's the same instruction that was read on the other one,
Yes,
but
ma'am.
I'm going to have it in written form. And then, State, are you requesting any of the category 2s? Defense, are you requesting any
No,
of the
Your Honor.
category 2s?
No.
No? Okay. So 15.1 is robbery. Any objections to that one?
No, Your Honor.
14.1 is grand theft of a motor vehicle. Any objections to that one?
No, Judge.
And the original 8.2 is going to go back in here.
Oh, yes.
Then 3.3, possession of firearm. All right, there is no lesser included of possession of firearm by a convicted felon. So we're done with the lessers. All right, so now we have the possession of firearm, discharge of a firearm causing great bodily harm instruction. Any objections from defense?
I'm sorry, Judge, you lost me. What page are you on now?
3.3, we're on page 36.
36, okay.
Yeah. Because the counts all include firearms, counts 1 through 4 include firearms.
Right.
This is the possession of firearm, discharge of firearm. Well, counts 1 through 5 all include firearms.
Okay.
So this is the standard instruction.
Count 5 is not a 1020 life crime anymore, so. There.
You didn't charge it as a 1020 life? Honestly, I paid almost no attention to count 5. Y'all didn't charge it that way?
We did, as a firearm by felon. I don't think it's a 1020 life pursuant to this instruction anymore. Nothing you guys saw. No, I'm sorry, it's in here.
It is, I was going to say, it's in here. Yeah. It's been a very long day, so.
But it's only as to possession, not discharge, for the count 5.
Let me know when you're ready to comment on this one, Ms. Moreau. Do you have any objections to this instruction?
No, Your Honor,
Okay.
to the aggravation. No.
3.3A, aggravation of felony by carrying a firearm.
No objection.
All right, now we're going to get to insanity. All right, the issue in this one was the last paragraph.
Correct.
State, what's your position on the last paragraph?
I'm taking it out.
You don't want it?
I think the court's obligation is to instruct the jury properly, and I don't think there's any set of circumstances in which he would be released from custody regardless of the verdict. Jury that you must conduct further proceedings.
Well,
But on this case, you would be.
the weird thing is, if he was found not guilty by reason of insanity, I still have to have the commitment hearing.
Yes,
But he's never going to be released.
that's my point.
I thought
I
we-
will leave,
about-
whatever the defense wants, I don't have an opinion on this one, Judge.
Yeah, I thought we all had agreed on this, because at the beginning of jury selection, the way we dealt
We
with
haven't,
this.
we've agreed something has to be read, but we haven't agreed on the wording. So my proposed wording would be, if your verdict is that the defendant is not guilty by reason of insanity, that does not mean he will be released from custody. I would take out the word necessarily. And maybe just put a period there. I don't know,
Why is it in italics, Judge?
because we had to talk about it.
Oh, it wasn't, that's not the
It's
way
not
it's
an,
in the...
it's not going to look like this in the end.
No, but in the standards,
No. The italics and the bold are the things that we had issues with and have to
Okay.
talk about. All the type will look the same.
okay.
So I'm saying, if I just read, if your verdict is that the defendant is not guilty by reason of insanity, that does not mean he will be released from custody. And put a period there.
I object only because,
What are you objecting to?
only because if the jurors are confused that he's going to get out and decide that they're going to vote against it because of that,
It says that does not mean he will be released from custody.
I'll just bring up what you said.
What
about-
is it you want it to say?
He will never get out. He will die in prison. It will be
Well, I'm not going to
sufferable.
use that terminology.
He'll be in isolation.
I'm not using that terminology, so if you want to try again, you can.
Okay, we'll go with yours.
All right, so just have it read, take out the last sentence, which is, I must conduct further proceedings. All that's going to do is confuse them. They're not going to be able to follow the distinction. And we have told them he's serving life in prison, so.
And I'm clear, the defense has no objection to removing that second sentence.
You're
No-
not
no
objecting?
objection.
Okay. And the court has denied their request for whatever it was that he wanted me to say, which I didn't write down, but I'm sure the court reporter got it. All right. 3.6H, justifiable use of force by a law enforcement officer. Any objections to this one?
No objection.
All right, that would bring us to justifiable use, the one that the defense is requesting. State, you wish to be heard on this?
Yes, Your Honor.
Go ahead.
Objection is, I think, the simple one, the
I'm sorry.
paragraph down, which starts with Markeith Loyd was justified. The second sentence of that indicates that if Markeith Loyd was not otherwise engaged in
Yeah,
activity, which is a stand your ground.
that one's out.
Judge, I'm sorry, what page is that on? It's not the next page.
This is your all's requested
Oh, okay,
instruction.
okay.
Yeah, hold
Yeah.
on. You can sit through this, Mr. Brunsmith, thanks.
I don't think he's entitled to that second sentence because he was engaged in criminal activity. The statute changed in 2014,
Yeah.
precluded.
Yeah, I'm not reading that.
Okay.
You got it?
Yep.
All right, so that's the simple one. There's another one in here that is a stand your ground. Let's do the two stand your ground ones. Go to the second page of this. Go to that last how the defendant had no duty to retreat.
Yes.
That's a stand your ground language, and that he's not entitled to that.
I agree.
Any other changes that are requested by the state?
Yes, Your Honor.
Which ones? All
We
right.
don't have an objection to the first paragraph. The second, third, and fourth paragraph, I don't think are applicable in this case. In the jury instructions, it does not say that that is to be read in each case. That is read as applicable to the facts of the case. Here we have the above paragraphs are, if you read them the way they are written, if you read them, it would basically permit a defendant to use deadly force each and every time an officer pulls a weapon to effect the arrest of somebody or to take a felon into custody. The language up there in paragraphs 2, 3, and 4 pertain to a situation where you have a layperson who doesn't have the authority and the right to use a firearm to take a felon into custody or to use whatever force is reasonable. So if you read those 3 paragraphs, paragraph 2, 3, and 4, and then you read the paragraphs dealing with the justified, the law enforcement officer's justification of using force, they're inconsistent. So my suggestion would be to read the first paragraph and then begin with the paragraph starting, a person is not justified in using force to resist an arrest by a law enforcement officer, and continue there.
So just so that we're clear on the record, you're saying, read, it is a defense to the crimes of first-degree premeditated murder of a law enforcement officer, first-degree murder, second-degree murder of a Leo, second-degree murder, and manslaughter if the actions of Markeith Loyd constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great is distinguished from slight, trivial, blah, blah, blah. And then jump to the last paragraph on the page, which is a person is not justified in using force to resist an arrest by a law enforcement officer or to resist a law enforcement officer who is engaged in the execution of a legal duty if the law enforcement officer was acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. Then go on to the next page. However, if an officer uses excessive force to make an arrest, then a person is justified in the use of reasonable force to defend themselves, but only to the extent he reasonably believes such force is necessary.
Correct, Your Honor, because
And I'll get to the rest of it in a minute.
that
All
last
right.
paragraph that you read, starting with however, addresses the defendant's ability to use whatever force is necessary in this situation.
All right, defense, you want to be heard on this?
Yeah, Judge, I need to see it because we can't find it. What page is that on?
This
the
is your
jury?
instruction.
It's your requested instruction that you
Oh,
emailed
okay,
to all
I
of
can
us.
find that.
Nan, did you count how many copies we need? You're my counter. Well, court
So
reporter.
which paragraphs, Rich? Al?
All right, so look at, here's the paragraphs we would take out. Paragraph 2, the use of deadly force is justifiable if Markeith Loyd reasonably believed that the force was necessary to prevent imminent death or great bodily harm while resisting another's attempt to murder him. And then the paragraph following that that starts with Markeith Loyd was justified in using deadly force. Those two would come out. So I would read paragraph 1, and then the last paragraph on that page, it says a person is not justified in using deadly force. Then go on to the next paragraph, which is, however, if an officer uses excessive force.
Yeah, so what is the reason that those first two come out?
Not the first two. The first
sec-
paragraph stays, paragraphs 2 and 3.
Okay, the use,
The state is saying that if I read that, basically anyone who's being arrested by a law enforcement officer who's drawn their weapon is justified in returning fire.
Yeah, but there's other predicates that go into that. That's just not alone. There's other predicates that have to be met.
So I don't think that the paragraph that is, the use of deadly force is justifiable and ends with another's attempt to murder him. I don't believe that that needs to be read. I am inclined to read that first line of the next paragraph. Markeith Loyd was justified if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself, because then it's immediately qualified by, well, actually, that's not true. The problem is that the law surrounding arrest and lawful arrest by an officer.
I
The
believe,
law is pretty clear that you can't resist with violence, except if the officer is using excessive force. And that's been the law in Florida for as long as case law has been around. You cannot resist an officer with violence unless they are using excessive force against you.
and that legal concept is covered in the paragraph
Right.
below. So I think the two paragraphs are inconsistent if read together.
I agree with that.
Okay, so I'm going to take out those two paragraphs completely.
The use of force is justifiable and another's attempt to murder him. Right.
Yeah, I'm going to take that out, and then the Markeith Loyd was justified in using deadly force. So I'm going to read the first paragraph, then I'm going to read the last paragraph on that page. A person is not justified to resist arrest. Then I'm going to read, however, if an officer uses excessive force, then a person is justified. Then we get to the next paragraph. In deciding whether Markeith Loyd was justified in the use of deadly force, I think that one should be read except for that last sentence, which is a stand your ground defense, which he's not entitled to.
I agree, Your Honor.
So I
Come
get-
up here and look at this, Mr. Letterman.
All right, I can see what, the one you're talking about, you're taking out after another attempts to murder him.
Yes.
You say you're taking that out.
And I'm taking out the next paragraph that starts, Markeith Loyd was justified in using deadly force, because it contradicts what the next two paragraphs say, and it's also not Florida law.
Okay, so, but going back to the other one.
What other one?
The one above that.
In defense, it is a defense of the crimes of first-degree murder?
No, Markeith Loyd was justified in using deadly force if he reasonably believes that
Right.
such force was necessary. Is that somewhere else in here? Because I think that's the law.
Yeah, if you keep reading, keep reading.
Okay. I get the duty to retreat comes out.
Well, yeah, retreat was going to come out regardless,
Right.
because that's stand your ground. The rest of it I would read, other than the stand your ground line that we took out.
So in deciding whether Markeith paragraph, you're getting rid of the last sentence.
That one's being read, except for the last line, which is a stand your ground defense.
Right. So I don't think that the first part of the sentence up here is adequately covered. And so I'm talking about Markeith Loyd was justified in using deadly force. I agree that
You cannot use deadly force when being arrested unless the officer uses excessive force, which is covered in the last paragraph, in the
Okay.
top paragraph of the second page.
no objection.
All right. Let's move on from this one. We've come to a decision about this one. All right, 3.7, plea of not guilty. Any objections to that one? It's a standard.
No objection. Judge.
3.8, evidence of other crimes. Williams rule. Any objections?
No, Judge.
3.9, weighing the evidence. I take it, did you take out the defendant testifying?
I did not, but I will fix that.
I also had a question about you must consider the testimony of some witnesses with more caution than others. I vaguely remember discussing it, but I don't remember why it was in here.
It was in there because of the claim in the first trial that Brian Stribby got some kind of a deal. That was vaguely brought out in this case, but I still don't think there's any evidence of it, so I have no opinion one way or the other, Your Honor.
Defense, you asking for that paragraph?
Yes.
All right, we'll leave it in. So you gave me two 3.9s, and I can't remember why you gave me two 3.9s.
One
Oh, yeah, the
defendant
second one has
testifying.
the defendant has become a witness.
Correct,
So
Your Honor.
Let me get rid of this one. All right, so 3.9's good with the paragraph about defendant testifying. 3.9A is being removed as the defendant has testified. 3.9B, defendant statements. That's usually a confession one.
I'll defer to the defense, Your Honor.
Yeah,
There.
I don't think that should come in.
What?
I don't think it should come in.
Okay, so 3.9B is not coming. 3.10, rules for deliberations. I didn't see any problems with this one. All right, remember, I'm going to stop at this point. I'm going to read all of this and then stop at 3.9, and you all, at 3.10, you all will do your closings. So I'll read to the end of 3.9.
Okay.
Cautionary instruction, 3.11. That's a standard.
Right.
3.12,
That's fine, Judge.
I'll get to the verdict forms in a minute, but, all right. 3.12A, single defendant, multiple counts. Any objections?
None.
3.13, submitting the case to the jury.
No objections.
This is the one where we took out,
Took out the cell phone stuff,
we took the cell phone out,
and I changed the language on,
the exhibits.
yes, ma'am.
Okay. All right, so that one's good. All right, verdict, as to count one. Any objections to this one? It's in order, right? Yep. First degree, second, manslaughter, yep. Not guilty by reason of insanity. Any objections to the verdict as to count one?
No.
All right, verdict is to count two. I have to tell you, I did not hear Dr. Toomer, and I did a word search yesterday, but I'm not 1,000% sure on what I'm saying. I didn't hear him say, his entire opinion was he was not guilty by reason of insanity. He was insane at the time he shot Clayton, but I don't remember him giving an opinion on any other count.
No, I don't, we don't want any other count.
So we agree that the only evidence that was offered was as to Clayton on insanity?
Yes.
Okay. So on count two, we're going to take out F, defendant not guilty by reason of insanity. And so we have, let me make sure the order is correct. First degree, second, attempted manslaughter, and not guilty. Any objections to count two with the removal of not guilty by reason of insanity?
No, Your Honor.
All right. Verdict is to count three. Ag assault, improper exhibition, assault, take out, defendant not guilty by reason of insanity.
Correct, Judge.
Okay. Count four, carjacking, robbery, grand theft of a motor vehicle. You need to add assault to this
Right.
one. So D becomes take out, not guilty by reason of insanity, and add assault.
Yes, ma'am.
Defendant not guilty. And count five, take out, not guilty by reason of insanity, and this one has no lessers. Possession of firearm, defendant is not guilty. Special verdict forms. Any objections to the special verdict form? This is
No,
as to
Judge.
count one.
No, Your Honor.
All right.
Do you want the special verdict forms after the verdict form for count one, or do you want all the specials at the end? Or do you care?
I can reorder it, but
Because they're numbered, that was the only reason.
Yeah, I'm thinking I want it to be after count one so that they know you need to make these decisions and then you need to make this decision as to count one. So they're not going back and forth. It's a lot of instructions. All right, so special finding regarding count one. Oh, that's the continuation of the manslaughter thing, okay. Then special finding count two, this again is the weapons findings, or the firearm findings. Any objections as to count two?
No, Judge.
All right, any objections as to count three?
No, Judge.
Okay. Well, count three doesn't have the special finding, I'm sorry.
Correct.
Count four is the one I'm talking about. Jeez, okay. Any objection as to special finding as to count four? That's just possession of a firearm.
No, Judge.
And then count five does not have a special, well. All right, I actually can't remember, and I don't know if it's because I'm really, really tired. Do you have to do the special finding on possession of firearm by a felon?
Yes, and I'll add it.
I think you do.
We do.
It's
That's
that
my fault.
weird one where even though you have to find it to convict him, you still have to have the special finding that he actually possessed the firearm. So
Correct.
you'll do
That
the special
last
finding
page-
on that one,
On page
yeah.
66, it should be count 5.
What?
It should say count 5 on there, not count 4.
What does it say?
Count 4.
Oh. Mine
page
says count 5.
66.
Now, there's two special findings for count 4. One dealing with the carjacking and robbery for 1020 life, one dealing with the enhancement of the firearm for grand theft.
And then do
Okay.
we have to have one for assault?
Not misdemeanor assault, no.
Oh, that's right, it is the, I keep thinking it's aggravated assault, but it's not, it's the misdemeanor assault. All right, so count 5 does require a special finding,
Yes, ma'am.
so we'll add that one. All right, Mr. Buxman, if you would make, how many copies did you say, 24? We need 25 written copies of this. Please don't staple them together in case we find a mistake. It's a nightmare to unstaple all of it. And if you would please send me the electronic version of this also. And aren't you glad we're not starting until 10 tomorrow morning, folks?
Will do, Your Honor.
All right. Have a good evening, folks. And each one of you asked for 2 hours approximately for your closings? Yes, Your Honor. All right, gentlemen, have a good evening, get some sleep. I'll see you all tomorrow morning at 10 a.m.